And welcome everyone to the 38th edition of the Deserve to Win podcast. As always, I'm your host, Eric J. Troutman, the czar of the TCPA, the czar of just about everything these days. And I am really kind of thrilled because today our little podcast is going to focus on the interesting world of professional TCPA litigators, and we're going to bring you an interview with David Tom. Now, this is just a guy that files TCPA suits, and I figured you, my beautiful, wonderful, Deserve to Win TCPA world audience, would like to hear what's going on in the heads of guys like this, and we are going to give you the opportunity to dive deep into what this guy is thinking, or perhaps not thinking. But before we get to all of that, let's find out who we have and who is to my left.
Hi guys, my name is Brittany. I am a partner at Troutman Amin, also known as the Baroness of TCPA World.
Wonderful to have you, Brittany. And to my right, my redhead. No, wait, my redhead is missing. Who do I have?
It's kind of brown now. But hi, I'm Tamanna. I'm an associate attorney here at Troutman Amin.
The powerful Tamanna. You don't have a title yet.
She does.
It's on the plaque.
It's on the plaque? Okay, so we got to announce the title, but maybe not today. We've got a packed house, a packed show. We don't have time to waste talking about Tamanna's title.
Ceremony.
That's right.
She needs a ceremony,
Okay.
she said.
And who else do we have?
Hi, I'm Pooja Amin, partner here at Troutman Amin, also known as Queenie.
You look amazing today,
Thank you.
I might add. You've got something interesting on your finger. I'm not sure what that is. But let us move forward. First, lots of stuff to cover. Cal lost the big game. I just had to start with that because I can't handle it. But we're going to live. We're going to survive. Apparently, I have to do some kind of thing on LinkedIn as a result. This is a terrible situation. All right, so let's start with the huge Optum case. This is a really big win here in California. Very impressed. So this is the first time that I'm aware of where an insurance authorization message was found to be exempt from the TCPA under the emergency purposes exemption, which when you first think about that, you think that doesn't make any sense. But then if you really kind of play it out, maybe it does. So what is the, what kind of message are we talking about here? So, I mean, you guys know how insurance works, right? Not the greatest thing in the world. You go, you break your arm, oh my goodness, I need surgery. So you think you can just like walk right in and get surgery, but no, not necessarily, right? That insurance company has to authorize the treatment of your arm getting put back together. And so, you know, while you're waiting in the hospital, or maybe you go home and you're waiting for that authorization to come back, eventually you do get the authorization, and it might come in the form of a text message or an email, or in this case, it came as a phone call, as a pre-recorded call. And the pre-recorded call was notifying the customer, the insured, hey, look, good news, right? Whatever it is, I just use the example of having your arm broken. I actually don't know what the treatment was, HIPAA. But, you know, whatever it was, hey, congratulations, it's been approved, right? So that message went out. The problem is that the message went to the wrong person. And so a individual who was not the insured received this message and, in this case, decided that they were going to sue Optum. And Optum, very brave. This is a very brave decision that they made. They decided they were going to challenge at the pleading stage that the message was sent for an emergency purpose, arguing that a urgent notification of an authorization to receive treatment was a emergency healthcare message within the scope of the statute. Very brave, and you know what? The court actually agreed with them. The court found, in fact, that this kind of urgent notification regarding a healthcare authorization for treatment is, in fact, an emergency. And of course, it might depend on what the severity of the health-related illness or treatment that's required might be. But in this case, the court found that assessment wasn't necessary. It just looked at the content of the language itself that said this was an urgent notification regarding healthcare. And the court said that alone makes this an emergency situation and makes the call exempt. So even though Optum sent a pre-recorded call to the wrong number, this person, in fact, was not permitted to sue because the message was deemed exempt. Very unlikely ruling. I'm not going to lie to you. This was a very brave ruling. I could see a lot of courts, you know, not being brave enough, frankly, to pull the trigger and issue a ruling of that sort. But this court did, and I'd love to see it. I think it's a great ruling, and I think it does make sense if you really stop to think about it, that obviously, you know, these kinds of messages should be treated as exempt as an emergency. So that's one thing I want to talk about. The other thing I want to talk about, things that I love, right? Big wins in the TCPA and reductions in robocalls. A massive, massive drop in October. 1.2 billion less robocalls in October alone from October of 2024. Now, this is a particularly notable development because for the last 12 months leading up to October 2025, every single month, robocalls had increased. And robocalls dropped so much in October 25, so much, that it reached the lowest level that robocalls have been at since January of 2021. So we're talking about 4 years since the last time we saw robocalls at this level. What in the world happened in October? Like, why did robocalls just plummet to such an extreme degree? Can we think of anything that happened in October? Oh yeah, I announced my run for Congress, laser focused on stopping robocalls. And as soon as I come out and I make that announcement, all these guys out there in the telecom space, all these carriers, all these platforms, all these guys that are out there making their outbound calls, who do they listen to? Who do they follow? The czar, right? I mean, I just have this cult following of adorers, and look, they're all paying attention to my every word. They're all hanging on my every word, including some of these bad guys, right? These bad guys obviously got word that I'm coming after them, and you know I'm going to. You know, I know where they're hiding. I know what their techniques are. I know what their tactics are. I'm going to put a stop to it, and they know that. So what are they going to do? They're going to turn it off, like the lights go on, boom, the cockroaches scatter, right? These guys don't want any part of me in Congress, and so they're going to lay low a little bit. This is what I think. I don't know this, of course, right? I don't know this. Nobody tapped me on the shoulder and said, hey, we're going to stop doing robocalls because we don't want you in Congress. But this is my supposition. And if, the calls keep dropping, you know that this is a cause and effect. If the calls go back up, I don't know, maybe it was me, maybe it wasn't, but I think no matter what, the czar spook effect in October was a very real thing. You know who else should be spooked right now? Would be Dave Min. I mean, this guy wants nothing to do with me. I feel so bad for him. I really do. I was looking at some of his arrest video from the DUIs. Oh my goodness, there's just so much beautiful stuff for me to play with when the time comes. I hope he drops out. I really don't want to ruin anyone's career. But we'll see what happens. But what I do know is that politics is going to be a really good time, and I'm looking forward to it. I'm having fun so far. So much support. I love you all, by the way. Those of you who have donated to the campaign, you've all been wonderful. It's really been a great time so far. But enough politics. Let's get back to TCPA. What do we got, Britt?
So I have a case on personal liability. It's Rayburn versus Centene Corporations. This case was filed in the Eastern District of Arkansas against several defendant entities and an individual defendant named Monica Reed. So the complaint alleges that Monica Reed was a managing member of Satori Insurance. And Satori Insurance allegedly was the entity that made calls on behalf of Centene Corporations to the plaintiff. So of course, Monica Reed, not wanting to be stuck in the suit, filed a motion to dismiss, arguing that the complaint contained insufficient allegations that she actually initiated the calls to the plaintiff or was involved, had the right to control the manner and means of the calling conduct. Unfortunately for her, the court did not want to remove her from the complaint. She's still stuck in this case. The court, as it must at the motion to dismiss phase, credited the plaintiff's allegations in the complaint, which said that she was involved in making the 300 calls to the plaintiff. So she's facing up to, I don't know the math, $450,000
That would be
exposure.
The math. Good job.
$450,000 in exposure, for her. And thankfully, this is not even a class action case, because if it was, we'd be talking about millions and billions of dollars that she could be potentially on the hook for. So this just serves as a reminder to all you folks that, are even working at a call center, own a call center, that even if you're the agent that's calling a consumer, you can be on the hook for the TCPA and named personally in these lawsuits.
No, I love that. And people think, hey, look, they're not going to come after me, right? I'm just a lowly agent. They might want to go after the insurer, in this case, Centene, maybe the agency, right? But me, poor little Monica Reed, it's a great name, by the way. Very literary. It feels like a sitcom character, But no, Monica Reed got sued personally and cannot get out of the case, right? So no matter who you are, I know we've got a lot of real estate agents that listen to this, a lot of insurance agents, you can be personally sued. Even if the big corporation is also named, you can be named too, right alongside them. Monica found out the hard way. You guys really need to take TCPA compliance seriously. Of course you know that. You wouldn't be watching the show if you didn't. But thank you for the reminder, Britt. Good stuff. Tommy, baby, what do we got?
So this is a bit of a continuing story, and we here at Troutman Amin have been covering it from the very start, and it concerns Texas SB 140. But for some context, Texas's mini TCPA, like many state mini TCPAs, requires registration of sellers that are making telephone solicitations into Texas or out of Texas. what happened in September this year was that Senate Bill 140 went into effect in Texas. And this bill, among other things, expanded the definition of telephone solicitations under Chapter 302, which is where the registration requirement is. And it brought within the purview of telephone solicitations text messages and graphic messages. Previously, it was just telephone calls. But notably, the plain text of the statute, a plain reading of it, meant that even calls and text messages that were sent with consent would still be covered. So even businesses that were only making calls and text messages with the consent of the recipient would be required to register. And with registration came a pretty hefty deposit, as well as several disclosure requirements. But just a few days after this bill went into effect in September, a lawsuit was filed against the Secretary of State of Texas, the State of Texas, and the Texas AG, essentially alleging that SB 140 is an unconstitutional restriction on commercial speech, and that the bill, when it was being debated in the Texas legislature, never intended to include consented to text messages. There's been some back and forth. The Texas Secretary of State and AG filed a brief essentially saying that their understanding of the bill is that consented to text messages were never supposed to be covered. They're bringing in a definition of telephone call from a different chapter. But recently what's happened is the parties in this lawsuit have filed a joint motion to dismiss, which a court recently granted. And as per this joint motion to dismiss, the Texas Secretary of State has said that their understanding is that if you're making consented to calls and text messages into and out of Texas, you do not need to be registered under this bill. And while this is a helpful clarification, it's still important to remember that this is just what the Texas Secretary of State is saying. This is not a court looking at the statute and saying, hey, this is how we interpret it. So until a court really comes in and confirms this reading of it, the safest route would still be to continue to register, especially because there will still be private plaintiffs who will test out the theory under this bill and try to file lawsuits.
Is it a clarification at all? I mean, so I'm still a little confused in terms of what this even is. And understand, the law as written, right, there's a special definition in a different section, right, that uses a different phrase. The section that is the registration section uses a totally different phrase, different words. And the AG has said, well, the court should interpret the registration section, which has different words, to adopt the special definition applied in the other section. That makes literally no sense. That is not the way statutes are constructed. Actually, it's quite the opposite. So the interpretation rules that are being imposed or suggested by the AG fly in the face of how statutes are to be read. So these two parties have just like agreed, oh, for this case, we'll go on our merry way, can dismiss the case because our understanding is X. And we're all just kind of looking at each other like, what do you think you just did? Because you didn't do anything, right? It's not as if the court has ruled definitively, or the Supreme Court has ruled definitively, or any agency with implementation power, or any legislature has found that this weird, let's use that other phrase that's a different phrase and graft it on here, rule would possibly apply. So I'm looking at this and there's like a lot of like kazoos and champagne corks, and I'm like, what am I missing? And maybe I'm missing something, right? So to my eye, as a litigator, obviously, right, if my client gets sued and they haven't registered for whatever reason, I'm going to argue, hey, look, Your Honor, even the AG agrees that my client didn't have to register because the words here that are different words, and we just graph that over, move it on, and apply it. Everything's fine. It's like the cut and paste feature with WordPress. Like, who cares? But between you and me, I'm not sure that's the way law works, guys. In fact, it's just not. So I would continue to be as cautious as you can possibly be. I would, until we get actual case law, and really you're talking about like at the level of the Fifth Circuit Court of Appeals before I would start feeling comfortable, or at the Texas Supreme Court, right? Like those are the two level of courts that I would want to see ruling on this before I feel comfortable not seeking registration, even for consented communications. And I'm sensitive to the fact that the legislature might not have intended this result, but guys, words are words, right? And the express language of the statute is the first thing that these courts are supposed to look at. And the express language of the statute here, it does not graft on the special definition from the other chapter. It just doesn't. So we got to be real careful, just real careful. That's all I'm going to say about that. But Tommy, I really appreciate you covering this hot and heavy story, man. It's like windshield wiper fodder, man. It's like can't get rid of it fast enough because it just keeps dripping down and obscuring your vision. I'm telling you guys, like you don't want to think what these guys are telling you. You want to take care of yourself and keep yourself safe. What do you got?
Well, I wanted to add one more thing on that. Sorry. And then keep in mind that consent is your defense with these registration cases, right? Just like they are with TCPA. So plaintiffs' attorneys, they have no problem bringing in TCPA mixed in with the registration case because at the end of the day, they know it is on you to prove that consent requirement either way. So, even though arguably you have consent and that's why you didn't get registered, if the courts or if the plaintiff's attorneys are able to show, well, you didn't have consent to not only make the calls, but you also didn't have consent where you had to escape the registration requirements, right? Like plaintiffs' attorneys don't want quick settlements by just alleging those causes of action. So nothing here is going to prevent people from filing those causes of actions mixed in with TCPA lawsuits or the Texas telemarketing statute as well.
It's actually a really interesting point. So even if, right, this weird Frankenstein's approach to law were to be adopted, if they can't prove consent, they have to have that registration anyway.
Correct.
It's an interesting point. What else you got?
So this one's fun. I love this one as a compliance lawyer. We know TCPA class action suits are expensive, they're costly, right? But one defense strategy that is so meaningful in the TCPA space that a lot of folks forget about or don't know how to compel in a meaningful way are arbitration terms, right? And how arbitration, like folks miss how meaningful they can be when you're working with lead sellers and lead buyers and whether you're generating leads on your own website and just having those robust arbitration terms or requiring your partners to have robust arbitration terms is extremely important. And the case of Ashworth versus Credit One Bank is an extreme reminder as to why arbitration terms can be so valuable in these costly litigations. So in the Ashworth case, the defendant Credit One alleged that they sent after plaintiff filled out a credit card application, the credit card agreement, including arbitration terms, after the plaintiff had submitted its application. So the Credit One, the defendant, informed the court they had evidence that they mailed out this agreement and therefore their motion to compel arbitration should be granted. Plaintiff instead argued that, well, no, hold on, I didn't sign anything. And more importantly, you did this sneaky, hidden way of providing me these arbitration terms and it got mailed to me. I wasn't aware of it. It wasn't conspicuous enough. And instead, the court found in favor of the defendant by saying that because they had evidence that that agreement with the arbitration terms was in fact mailed out to the plaintiff, that there was arbitration notice available here. And just like that motion to compel arbitration was granted and the defendant won, i.e. the case moves now to arbitration, helping Credit One to get out of that TCPA federal class action lawsuit. So, courts, in different states look at arbitration terms. If you're in California, you're going to need some more conspicuous disclosures, but this case was out of Alabama, I believe the Middle District of Alabama, where the court essentially said, you showed that there was notice, regardless of whether that plaintiff signed, agreed, looked at it, read it, arbitration terms existed here. So just really, it's something to keep in mind. I know in cases where like credit card companies or insurance companies or even like car dealerships, you'll see long agreements being sent to you after the fact, after you purchase something. And, those terms have meaningful defenses available there when you're sued in the TCPA lawsuit, but you have to keep in mind that those are available. And more importantly, if you are folks who don't send out long, lengthy agreements, but you're just relying on website, right? Make sure that your lead providers have those arbitration terms within their website that include you as a TCPA seller as well.
Fascinating stuff. Credit One, very successful TCPA litigator from a defense side. They've got a great track record of victory. I was actually moved by the evidentiary showing in this case. It was laser tight. It was very well done. And I used to do bank operations cases. I know how hard it is to get declarations and proof that a mailing took place and a version was done. And it can be it can be challenging to you think proving up web forms is hard. Try proving up what showed up on a POS screen at a bank deposit. I mean, it can be very challenging. So I was pretty impressed. I thought they did a really nice job. I think the court was impressed. Honestly, this was a tweener. It could have gone either way on the evidence, and the court I think had no problem crediting credit one, because I think they did a really nice job, and you did a really nice job. So thank you very much. What do you ladies think? Should we talk to a guy with 2 first names?
Oh, David Tom.
Yeah. So now, through the power of Troutman Amin LLP, we are excited to bring you an interview with TCPA litigator and 2 first name aficionado, David Tom. And now, through the power of Troutman Amin LLP, we are incredibly excited to bring you an exclusive interview with litigator David Tom. David, welcome to the show, my friend.
I'm glad to be here. I hope you all aren't too harsh on me, but we'll see how it goes.
We're going to try to be fair to you, but fair is a relative term. So let's just start with kind of the basics. Like you bring TCPA cases, or you have in the past. How many TCPA cases have you brought? Do you keep track of them?
It depends on how you want to define that. Whether it's me brought pro se or through counsel. Pro se, I probably got either somewhere between 12 and 14, but that amount's about to go up because a whole bunch of people they haven't responded to me over the past year and a half, and I've got to work. My wheelbarrow broke, so I got to get a new wheelbarrow so I can take it down to the clerk and file a whole bunch of litigation.
I see. And how many cases have you brought?
That number's about to go up.
How many cases have you brought with a lawyer?
With a lawyer, probably about the same.
Okay, so you're about 25 cases deep so far, right, as a TCPA litigator, and then you are about to take a wheelbarrow down to the courthouse. Now, like, what are we talking about here? Are we talking about another 20? Are we talking about 100? Like, how many do you have up your sleeve, man?
It's probably going to be somewhere more than 50, less than 100.
All right. So how have you found the experience of being a TCPA litigator? I mean, do you enjoy this? I mean, tell me about your mindset here.
I mean, it's kind of interesting. I have the unique distinction of hearing a Central Florida attorney named Cheney Mason speak once, and I know that you all are out on the West Coast. But Cheney Mason was a criminal defense attorney based out of Orlando. He worked on the Casey Anthony case many years ago. He worked on her defense team. And he was given a speech. He was receiving, I believe it was a Lifetime Achievement Award or something like that from the Florida Association of Criminal Defense Lawyers. And in his speech, he basically said, one of the things that attorneys and citizens of the people have to know is that you have to know your rights. And because if you don't know your rights, people are going to try to take them away from you. And when someone tries to take your rights away from you, you go to court and you tell the judge, I'm not letting these people get away with it. I'm not letting them off the hook. And if the judge tries to take your rights, well, you tell the judge to, and of course, there was an open bar involved and a whole bunch of attorneys began cheering. But that kind of stuck with me. And, with the absolute avalanche of calls that people out there get. I mean, my home phone rings every day, 50 to 100 times, and it's all the same thing. It's final expense, it's car insurance, it's car warranties, it's Medicare. You name it, they call and they try to sell it to me. And it's just like, it's frustrating. So it's like, okay, you know what? If these companies don't want to follow the law, well, guess what? We've got an avenue. We've got our private right to action. We're gonna take it to the courts, and the courts have been, you win some, you lose some, but some of the judges have been very receptive to hearing the arguments and the merits involving telemarketing cases. And I actually had one case somewhat recently. The judge basically said, I don't know anything about this, so help me understand this, talk me through this. And we had a conversation in court, kind of like we are right now. And she basically, in 30 minutes, she got a very succinct understanding and explanation as to how TCPA and our state equivalent, the Florida Telephone Solicitation Act, works. And she was thoroughly impressed, and she gave me the default.
Interesting. So now, David, look, I'm all for people standing up for their rights. Don't get me wrong. In fact, look, when it comes to civ pro and protecting your freedoms, especially in today's day and age, where a lot of our basic foundational freedoms are actually legitimately under attack to a degree that's really not been the case before. Being assertive for your rights is certainly an incredibly important thing. However, when we're talking about shaking down small businesses for a couple of dollars with the threat of a TCPA lawsuit, I mean, I don't see that as the same sort of thing in terms of kind of protecting one's constitutional rights from government overreach. In fact, I think that the TCPA is largely abused by folks. I'm not saying that you do, but I mean, look, you see small businesses, they get shaken down for $2,500, $5,000 in these frivolous cases, and what are they going to do? They're going to pay me $50K to defend them when they could settle the case for $5K, right? I mean, generally speaking, they don't.
I'll give you the perfect explanation. I just settled a TCPA case, and basically the details of which, the exact details are confidential, but I can tell you it's very large company engaged, had a broker or affiliate or agent or employee, whatever you want to call it, that type of relationship. And they hired a lead generator that went off the reservation and did a whole bunch of things that they weren't supposed to do. And right after I settled that case with a very large company, another very large company within that vertical also did the same thing. And I'm pretty sure they're probably buying leads from the same lead provider. And I got a letter sent out to them, and we talked on the phone, and they said, okay, well, what do you think we should do here? And I said, well, I just settled one of these. The settlement was, and I threw out the number, and they said, ooh, well, we're a really small company. We can't afford that. And I said, well, my position was, well, if you can afford to buy leads, you should be able to afford the liability associated when you purchase bad leads. And they didn't really like that answer. And they said, well, we're a small company, and this is going to put us out of business. And I said, well, to quote Dolph Lundgren from Rocky III, if he dies, he dies. If the small businesses don't want the liability of a TCPA case, whether it be an individual or whether it be a class action, they shouldn't be violating the TCPA. This is basically, we're going to go back to my old roots in Catholic school. If you don't want the punishment, don't do the offense.
Yeah, see, and David, this is why nobody likes you guys, right? Because you don't seem to care if the small business, who, by the way, their crime is not a crime, right? What they did was they trusted someone to follow the law. They bought a lead. Maybe they made an outbound call, or maybe they took a transfer. They're not trying to call someone they're not trying to call. They're not trying to call a bad lead. They just want to contact somebody who they're being told is interested in their good or service. I'm going to tell you, I'm a small business, right? If somebody says, hey, so-and-so wants to hear from you, Troutman, we're still small enough that it's valuable for us to get leads. So I can definitely sympathize with some of these small businesses. When I hear you say, hey, if he dies, he dies, I think to myself, man, you've lost touch of reality. I mean, look, like I said, I don't want to be mean to you. I want to be nice to you because I want to encourage people to come on the show. But I mean, that's a very hostile thing to say to small businesses who really live in fear here.
You know what? And it may be a very hostile thing to say, but I mean, it's the truth. If you don't want the liability associated with bad leads, don't buy bad leads. And it's easier said than done. But I mean, I tell these folks, and I run into them, unfortunately, on a very frequent basis. I tell them, I say, listen, good leads are expensive. Bad leads are really expensive. You're about to find out just how expensive bad leads are. And I mean, these lead generators, these third-party marketers, they sell these people a bill of goods. They're going, we got the best leads. Nobody's got leads like this. We've got big, beautiful leads. Our leads are tremendous. You got to buy these leads. They call me from everybody. They call me. They're like, where do you get these leads? And they fall for this shtick. They fall for this faulty premise that all these leads are great, and they're not. They're terrible leads. And then when they find out just how terrible the leads are, they're running for cover. They call the lead generator. They say, hey, there's this guy named David Tom. He's threatening to sue us. What do you want to do? And they disappear. And that's problematic for a lot of reasons. But I mean, it's I own a small business. My father had a small business. My father had insurance because he understood the concept of liability very, very well. My small business has insurance because I understand the concept of liability really, really well. But these folks, they are engaging in these practices where there's a tremendous amount of liability and they have no insurance. I gotta say, I understand where you're coming from. It's a small business, and we should be quote unquote kind to them. But if they don't have a basic understanding of liability, and they haven't prepared themselves, and they don't have the insurance for that, I'm not really going to lose a whole lot of sleep at night if they say, hey, this is going to shut us down.
I mean, do you take into account, though, whether or not they're trying to comply with the statute, whether or not they have, terms and conditions with the lead seller, where they're really trying to do the right thing? Because I get it. Look, if you're telling me there's a fly-by-night and they don't care what they're doing, they're using a call center in Pakistan, all right, fine. I've got a lot less sensitivity for that. But if this is like a good old American business, and their crime is that they went to a reputable lead source and they tried to buy some very specific high quality leads that are TCPA compliant. They buy the leads, and look, they got duped. They're a victim every ounce, if not more so, by the way, than you are, right? You were victimized because your phone rang. They were victimized because they had a deal and somebody broke that deal, right? That's victimization to a larger degree. Do you take that into account when you're going after these guys?
I do, and my answer is okay. Very much, and you've talked about this before. If the lead generator did all these misdoings, shouldn't the lead generator be brought into the claim as a counterclaimant? And I asked the questions to them just like that. It's like, okay, so you're saying that you didn't do all these things that I allege, and you're saying that someone else did. That's fine. Are you bringing them in as a counterclaimant? Are you making an unfair and deceptive trade practices claim against your lead vendor? Because if you are going to make that claim, I will provide you my GoPro video, and you can use that as evidence. And it seems like the conversations that I have with these folks, they don't want to involve their lead generator. They don't want to upset the apple cart. They get a lot of business from the lead generator. So I think they're viewing it from a perspective of, well, let's just pay David Tom or whoever complains and get rid of it. And this is the one bad apple out of the thousands that we've gotten from this produce vendor. So that's kind of how they look at it. They look at it as a numbers game. They don't look at it as a, hey, we should run a clean operation. They look at it as it's a cost of doing business. And for the people who look at it like that, I really don't have a lot of sympathy for them.
Now, do you fill out some of the forms that you think are bad lead forms to test the viability, or are you just getting calls and you never fill out the forms?
I don't fill out any forms. And what's funny is I will actually talk to some companies. They say, we've got the Jornaya token. You filled out the form. And I said, okay, really? I didn't fill out any form. The company that called me filled out that form on my behalf and ticked the box and plugged in everything because they needed to generate a sellable lead. And they say, well, we've got the Jornaya token right here. It says you were in, such and such proximity of your residence on such and such day at such and such time. And it's like, okay, that's really interesting because I wasn't in that proximity at such and such day and such time. So they're basically falsifying a Jornaya token to present the appearance of a genuine lead. For instance, if Eric Troutman, who lives in Irvine, was looking for car insurance, they would spoof a Jornaya token somewhere in the vicinity of Orange County to give the appearance that the lead was truly organic. And it's nothing but organic. If anything, it's AstroTurf.
So you don't fill out any of these forms because, one of the first things you said was you get like 50 or 100 calls a day. Man, I don't get 50 or 100 calls a day. I might get 2 or 3 calls a day. And don't get me wrong, I don't want robocalls any more than anybody else does without requesting them. But it's not like my phone is blown up. So how is it that your phone seems to be blown up to a crazy degree and my phone isn't? If you didn't fill out any forms.
My phone is a copper wire landline. It comes literally a line of copper comes out of my wall, goes right down to the street, goes to the AT&T substation that has been connected to my house for 41 years. I vote. I have a driver's license. I own businesses. The number was previously established with my father, who, if he were still alive, Dad would be 77 this year. So they're pitching all the Medicare. They're pitching all the final expense. They're looking for property owners. I own property. They're looking for business owners. I own businesses. They're looking, this phone number, through no fault of my doing, is in every single database. So when the database markers want to go whole hog, they have my number and they choose to call it and abuse it, even though it's been on DNC since my number went on DNC the day after the registry opened in June of 2023. So we're talking literally 22, almost 23 years here, and they continue to be non-compliant. And for that reason, I don't really have a whole lot of sympathy for them.
But you understand, if they have a consent, they're allowed to call you even if you're on the DNC, right? And that's the way these businesses operate. They're not trying to just hammer somebody who's on the DNC who doesn't want to be heard from. They're trying to communicate with somebody who they believe. I mean, look, we can say what we want about lead generators, and I'm on record saying some pretty nasty things about them. But in my experience, the lead buyers, I mean, are there some that turn a blind eye? Probably. Are there some that aren't as cautious as they should be? Definitely. But I've yet to come across a lead buyer that's just like, yeah, I don't care. I just want to put as many leads on and call as many people as I can and just harass people just in the hopes that I find someone that wants my product, right? They've got a bottom line too. They've got live agents. They don't want to waste their time or spend money on bad leads. So, I mean, again, I'm sure there is some percentage of people that fall outside of this, but in my experience, and I've got vast experience at this point, small business America relies on leads to drive growth and to keep a steady stream of revenue. They don't want to violate the law. They ask for compliant leads, and even if you're on the DNC, the law says that these individuals can contact you if you filled out a form. So all I'm trying to figure out is, you're getting blown up left, right, and center, but you say you don't fill out forms. But I hear you, right? Look, you've got a very attractive data footprint, so to speak, that would make you a target for some bad actors, and maybe that's what's happening.
Correct. I mean, I'm a target for every vertical. I have decent credit. I own property. I own a business. I vote. I own cars, so I have car insurance. I mean, I wind up being a really attractive target for these lead providers, because it's just like, well, what can we sell this guy? And the answer is damn near everything. So, so that's what happens. And, you were talking about consent. Consent is important, but we just had a case here in Florida. It's not a civil case, it's a criminal case, but it had to do with consent regarding a sexual assault case. And the case went to the Supreme Court. And basically the defendant in that case said, well, I got consent. The consent was from a third party. And the Florida Supreme Court roundly rejected that position and established that third-party consent isn't really consent. And I would make a similar juxtaposition in the civil arena, in that third-party consent isn't consent. I don't think it's a viable and tenable legal position. How that'll work out, we'll find out with the courts. But it's like you said. I mean, yes, they're relying on the concept of consent, but unfortunately, a lot of times I find that it's just basically been manufactured, or it's not organic consent; it's astroturf.
So you think sexual assault and phone calls should have the same level of consent requirement?
Consent is consent. If you look up the dictionary, it says, what is the definition of consent? We can look it up. Whether it applies to a telephone, a consensual telephone call, or a consensual intimate encounter, I would say consent is consent.
Interesting. All right. So what's your small business? You have a small business. What do you do?
So I buy and sell guns, and I also I have another small business. I'm a continuing legal education provider in the state of Florida, and we teach firearm law to a whole bunch of attorneys who have not a whole lot of formal experience with firearm law. So that's another thing that I do, and it gives me an opportunity to meet some of the state prosecutors and other civil practitioners in the area, and we talk and we get to know each other, and we get to kind of know each other on a more personal basis.
Okay. Do you ever buy leads, like as part of your business? Do you ever buy a lead?
No, never. Well, we never needed to, because number one, we discussed this. Good leads are expensive. Bad leads are really expensive. I'm not going to buy leads to do an outbound call campaign, because it doesn't work. The concept of me calling someone up saying, "Hey, I heard you want to buy a gun," that's a very strange way to approach business. So I don't do that sort of thing.
No, I guess that makes sense.
Yeah.
But so when you are approaching now your TCPA practice, I mean, are you happy when you get phone calls these days, or are you still kind of irritated and just thinking, I'm going to make these guys pay?
I'm irritated. It's irritating more than anything else. I used to work in corporate finance, and we were all remote, and I'm sitting on my desk, and I took a call from my boss, and she was basically firing me, and I said, can you give me some color on what's going on? And she says, well, every time we need to get something done, you're at home trying to work on whatever we need to work on, or we're on a screen share, or we're on a conference call, and your home phone never stops ringing. And I said, boss, what do you want me to do? What do you want? You want me to rip the phone out of the wall? I don't know what to say to that. And I said, I found it shocking that we've been on the phone for 15 minutes and we haven't been interrupted by a telemarketer. And just as I said that, I was interrupted by a telemarketer with my home phone ringing. So it's kind of like, I can't even get fired from my job without being interrupted by a telemarketer. This is the truest definition of adding insult to injury. So I kind of said, okay, you know what? I'm so fed up with this that I'm going to seek justice any way I can find it. And you know what? That's how it is. Do I seek these calls out? No. But you know what? When they come in, I will take every avenue available to me under the law to make sure that my rights and my right to privacy is represented.
Do you tell them to stop calling you?
Yes. And they don't stop.
Do you sue people who you didn't tell to stop, or do you only sue them after you tell them to stop and they keep calling you?
It depends on the situation, because a lot of times we were talking about lead generators earlier. The lead generator will call and they will say, do we have permission to contact you? Or we'll just use a real estate lead generator. They'll call and say, yes, we've got a licensed agent in your area. Do we have permission to get, does the licensed agent have permission to call you? And I will say, no, don't call me. Have them send me an email, and then they will sell the lead, and then the licensed agent will call anyways. So the licensed agent, unfortunately, was sold a bad lead, in that the lead generator was told, don't call, send an email. But because the lead generator only makes money when they sell leads, they do some chicanery. And the real estate agent that buys the lead, they think, okay, I've got a hot lead, I need to call it right away and get something moving. So a lot of times, unfortunately, the calling party did not have that direct one-to-one, hey, don't call, send an email. But I would argue that's neither here nor there. I mean, it's still problematic. So we do run into a little bit of that.
Do you sue only for calls to your landline, or do you have multiple numbers that you sue on? How do you feel about the litigator scrubs that include your phone number and put it on a scrub so that you can't be contacted by callers? Are you in favor of that, or are you against that?
I think it's an interesting position, because I've gotten calls where they've called me up, and in the interest of not offending anyone, I won't put on a Pakistani accent, but they will actually say, "Oh, you're a DNC litigator," and they will curse at me. They will say some very unflattering things about the sexual activities of my mother and my father, and then they will call me a whole bunch of names and then hang up. So I would argue that the litigator scrub, or the litigator list, it's a product that enables offenders to keep doing bad things. I mean, the analogy that I would make if I were to take a case to court would be, if you're speeding down the highway and you've got a radar detector and it says the highway patrol is running radar a mile down the road, it would be a good idea to slow down. That's one thing. But to have a radar jammer to jam the law enforcement agency from doing their job or getting any reliable data, or basically figuring out who's speeding, that's another thing. And I would argue that the litigator scrub is effectively acting like a radar jammer. So it's enabling these bad actors to continue doing business as usual. So in the sense that as a litigator, I don't like it, but from a business perspective, I think what they've done is it's quite innovative. It's really interesting. They figure out a way to do they figured out a way to do a whole bunch of illegal things and limit their exposure in getting caught.
But I mean, isn't it though that the litigator scrub is preventing you from being called in many instances? I mean, hopefully
it's not preventing anybody from being called. It's preventing the lead from being sold, and it's for being connected. So I still get calls every day, and it's, oh, you're on the litigator list. and they click and they hang up, and it's a spoof number, and you can't figure out who it is. So it's a tool that enables the bad actors continue to do bad things.
Interesting. So you're saying that essentially the lead buyer is deploying the scrub, but the lead seller has already made the call before they attempt the transfer, is what it sounds like to me.
I've had discussions with folks who were in the hot seat, and when I say in the hot seat, I mean their lead buyer got the letter and basically said, David Tom's going to sue you. They have the lead buyers have provided me with literally an Excel spreadsheet that says, we've checked this number on DNC, we've checked this on Litigator Scrub, we've done this, we've done done all of these preventive measures to keep you from getting sued from a known litigator. And it's like, okay, so if you've done all these preventive measures, how come I still have a GoPro video of the call? And the answer is always the same: I don't know. And it's like, okay, well, you don't have to know, but your seemingly impenetrable fortress got penetrated. So I don't know what to tell you.
Tell me about the GoPro video. Are you like recording yourself as you're answering these calls?
When I have a GoPro set up at on my desk when the call comes in, and it always says the same thing. It's always a fake caller ID. So it'll say unavailable, or it'll say city name and state. So if someone from Irvine, California were calling, it would say Orange County, CA. It wouldn't say any identifiable business. Typically, it's a spoof number. So it's kind of like, okay, when I see it says unavailable, or I see it says city, state, that's my clue that this is probably going to be some type of illegal telemarketing. And when 100 of them are coming in a day, and 1 or 2 of them are actually someone that I want to talk to, it's kind of like, okay, it makes it pretty simple. I know how the numbers are.
So what's your strategy in terms of pursuing the cases? I mean, like Diana May is someone that I actually talk fairly positively about. She's very, very aggressive, but she's a winner. She pushes these cases. She makes law for her side. I gotta, obviously she's on the other side of the V from me, but I gotta respect her tenacity, and she gets results. So far, when I look at your, you seem to just be kind of like filing and settling as opposed to like pushing these. And I'm just making an observation, not a criticism. Is that kind of your strategy? Or do you think you're gonna be pushing these further in the future? Kind of what's your mindset?
There's a couple that have pushed, and I mean, without going too deep into the weeds, I give everyone an opportunity to try to resolve things outside of court, because from the judiciary standpoint, if I have to go to court, they have the absolute right to say, Mr. Tom, what have you done to try to resolve this before taking up the court's time today? And I would like to be able to say that, Judge, I've sent them certified mail, I've sent them regular mail, I've tried to have conversations, they didn't want to come to the table, here we are. Some of them do come to the table and they're reasonable. Some of them don't come to the table and then we get a default. And then some of them basically have to be drugged into court, kicking and screaming, saying, this is, I had one attorney tell me, he said, you're holding my client hostage with this litigation. You're nothing but a bully. You're nothing but a terrorist, blah, 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 blah. And he said a whole bunch of unkind things. And I said, okay, so does he want to settle this or not? And basically he said, no, absolutely. He's gonna fight you and blah, blah, blah. I said, okay, all right, let's go ahead and give me the dates you want for mediation. Let's get the deposition schedules. By the way, I'm going to have a stack of requests for admissions heading your way. Let me know what your client thinks. And then 2 days later, after he presumably went over to his client and said, this is how much it's going to cost to put on a defense, we were on the way to settlement and we wrapped everything up. Some of them fight, some of them don't fight. But I mean, it's a lot like fishing. It tastes better when you catch it yourself. So I do enjoy I do enjoy a little bit of back and forth, but some of them have been a little more cantankerous than others, and some of them have basically said, hey, we're going to roll the dice, we're going to put this in front of a judge and a jury, and some of them have won, some of them have not, but we're going to play the game, we're going to fight the good fight.
Okay, and you've got a couple of default judgments, I think, and those are public record. Like, what's your highest judgment so far, if you don't mind sharing?
I got a default on as the liability only. The judge didn't sign off on the exact number, but it was something in the neighborhood of 145, 150,000, something like that. And it was just a case where they had made dozens of calls and they didn't show up in court. And I said, okay, all right, we'll ask for the default. If we get it, we get it.
So the future cases, you told me you had a wheelbarrow. You're going to be, bringing down all these cases. Are you bringing these yourself, pro se, or are you going to be working with attorneys?
I'm going to be bringing them myself. There are some cases where, if the other side wants to fight, if they want to hire the Troutman firm, great, terrific. I will hire counsel and have them work that. But a lot of them realize that it's just, when they're up against a GoPro video where, it's just like, okay, I've got a pretty compelling plaintiff's exhibit. Would you like to see a copy? I've had attorneys, they basically said, we have no interest in settling this case. And I said, okay, well, you're going to find out that I have this GoPro video in discovery anyways. Would you like to review it with your client? And they review it with their client. And then it's like, okay, let's play ball. What do you need? And that tends to be a very nice thing to have. And I find it really interesting because I'll get a letter back from the company or the attorney, and it basically says, we do absolutely none of the things that you say we do. And my witty rejoinder to that is, that's funny because I got a video that says you're doing exactly the things that I said I'm doing. And now that you've given me this document, I'm going to request that to be admitted, that you denied it. And then I'm going to put the video right next to it. And I'm going to let the judge and jury decide who's telling the truth. And that's gotten more than one deal closed in the past.
Okay, so at the end of the day, it sounds like you want to get to resolution with the people who want to resolve, but it sounds like you're not afraid to fight. At least that's what you're telling me. If you want to push and you want to fight, it's interesting. I mean, look, we live on our side of the V, right? We deal with the small businesses all the time. And they're not too happy with guys like you, right? And they think of you as you're saying, they think of you as an extortionist or someone that holds them hostage. Again, and you're saying you're just fighting for your rights. Maybe both are true sometimes, right? So I want to just kind of give you the final word here, like from your perspective. Most of the people watching this are small businesses, medium-sized businesses, big businesses. Some judges, some staff members at the FCC. Give them your best pitch as a guy that brings these suits as to why it is that the TCPA is not broken. In your view, it's not being abused, and these are appropriate lawsuits, and people should, if they die, they die, as you say.
Well, I mean, here's the thing, okay? I think the acronym the kids are throwing around nowadays is FAFO. And we won't get into the exact terminology of that on the podcast. Everyone can probably figure that out. But the answer is, it's like, if you don't want to do things that create tremendous bet the company litigation, size liability, don't do it. And I mean, it's frustrating for me sometimes because TCPA has a private right of action. FTSA has a private right of action. I will take a case to court. The attorney on the other side will file a document saying Mr. Tom's claim has no merit whatsoever. TCPA has no private right of action. FTSA has no private right of action. He's not entitled to bring any of these claims, and he should be taken out to the town square, placed in the stocks, and pilloried. And it's just like, well, hold on a minute. If there's no private right of action, what are we doing here? The FCC is not going to prosecute these people. The FTC is not going to prosecute these people. My state attorney is not going to prosecute these people. So then who is? And the answer is it's kind of up to myself and the other folks who are sick and tired of getting phone calls from illegal sources, from spoofed telephone numbers, et cetera, et cetera. And, it's like, okay, if the government doesn't have the resources to enforce that, I completely understand that. I respect that. But give the aggrieved parties the legal recourse to seek justice. And I think that's probably, the most perfect solution to a very imperfect problem.
Okay. Ladies, any questions?
When you do file, who are the plaintiff's attorneys you typically work with? Do you have a favorite attorney you like to hire for your case?
Usually it's Andrew Perong. Mr. Perong is he's a very bright guy and a very tough litigator, and he gets a lot of my cases. I have a local attorney here. He took over a case for me when they basically said, they said, okay, we're going to fight you. We're going to do this. We're going to do that. I said, okay, I'll hand it off to counsel. I'll pay counsel, and we'll let them resolve that. but I've got a couple other attorneys that I do business with, in varying capacities. But for the most part, Mr. Perron gets a lot of the TCPA cases that I want filed in federal court.
When you use your GoPro, do you tell folks you're recording on your GoPro?
Florida is a two-party consent state, so the first words out of my mouth, typically on recording, is "You're on a recorded line." So yes, that's usually how it goes. If I'm in a one-party consent state like New York or New Jersey, a little bit of a different story, but for the most part, if there's a two-party consent required, I make the announcement and I let them continue on with their sales pitch.
Did you really get fired because you received too many unwanted calls? I mean, is that really your story?
It was a big part of it. I mean, we've been on this podcast for 46 minutes now, and I mean, I've already missed something like 15 or 20 calls. I mean, it's insane. It's the rate at which they come in is just. I mean, I joke about this with the judges. Judge, they're calling they're calling faster than I can file lawsuits, and the judges, they get a kick out of that because they get these calls too. They're typically a little bit older, and it's Medicare open enrollment season, so they're getting these calls too.
Question. So you said that you're getting a lot of spoof calls. How do you determine who's actually calling you? How do you find out who your defendant's going to be?
Well, the answer is you gotta just listen to the pitch. And when the caller ID says Fifth Third National Bank, and it's got a local phone number, and you pick up the phone, and it's a robot saying that they can save you a whole bunch of money on car insurance, that's usually a tell. I actually, and you may find this interesting as members of the bar, I got it was an illegal telemarketing call, and the phone number and the name on the caller ID was displaying that of a local law firm, of which the principal had attended my previous continuing legal education seminar. So I kind of look at it and I said, that's interesting. Why is she calling me? And more importantly, why is she calling me at home? She doesn't have this number. And I picked up the phone, and it was somebody, up to no good, selling something that they weren't supposed to. Could not figure out who they were because they said, they had either realized they were being recorded. I was on the DNC list, or I was on the litigator list, whatever you want to call it. They disconnected the call. Right after they disconnected the call, I called the attorney and I said, "Hey, someone's spoofing your number." And she said, I know. We've called the telephone company. We've tried everything. We don't know what's going on here. And the concern for me was that number one, she's a patron of my continuing legal education business, so I consider her a friend, since she's a good person. But my concern for her was, could this get her in trouble with the bar? Because, as I don't know how things are in California, but here in Florida, attorneys cannot cold call, and attorneys cannot hire an outbound firm to cold call to generate business for their firm. So my concern was that her ethics, the ethical implications of that with a bar complaint could be somewhat substantial. So I let her know about that, and she had said that, yeah, it's a spoof number, and these this has been going on for years upon years, and she had no idea what to do about it. So it's kind of like, okay, now that I know this is a problem, I just got to kind of keep an eye out and see what's going on. But it would make me really happy for whoever that lead generator was to figure out who was buying the leads, talk to whoever was buying the leads, go back to the lead generator, and work with the local attorney here whose phone number is being spoofed to help her seek justice as well, because this is the sort of thing that's it's out of control.
It's crazy. Britt, anything?
It's no wonder that you've worked with Prong, because before he became an attorney, was also a serial litigator. But do you communicate with other serial litigators in Florida or anywhere else around the United States?
Occasionally, Pacer's a public record. I'll look up cases on Pacer. I'll look up the potential defendants on Pacer. I will see, hey, do these people have a litigation history? And, that's obviously that's a clue. And a couple times a year, I will pick up the phone, I will call, and I'll say, hey, my name's David Tom, I'm in Florida. I see you filed a case against so-and-so. If you can talk about it, great. If you can't talk about it, I completely understand. And 99% of the time, it's that case was settled, no comment, I can't speak about it. It's completely confidential, which I understand. But 100% of the time, it opens up a thoughtful conversation about TCPA, and it's just like, okay, you can't talk about that case. I get it. How did you get into this? And you tend to make some friends along the way. So it's kind of nice having people with interests who align with yours. So it's kind of it's nice in that regard. So I've talked to a couple people. I've made a couple good friends along the way, and it's a very interesting, strange way of meeting people in this day and age. But it works.
All right. Well, David, you've been a very good guest. You've said some things I can't get on board with, but overall, I think you've been very candid, and we appreciate you. So at the end of all of our interviews, we always ask the same question, and you can answer this however you want, but from your perspective, what can people do in life or in litigation or in lead gen to deserve to win?
Deserve to win, that's a... I was thinking about how to answer that question because I thought that it might come up. And, winning is, I play a lot of bar trivia, so I like winning. But, the key here is when you want to deserve to win, I think the key is first and foremost, you have to understand your liability. You have to understand the people that you're doing business with. And if you don't have a complete understanding of the liability and the people you do business with, I don't think that the winning mentality, that mindset, I don't think that those attributes go hand in hand. So I would say if your clients want to deserve to win, they have to know the people that they're doing business with just as well as their own business. And that level of sophistication you don't see very often. But when you do, I think that's a very important component and a very important I think it's an important attribute to have with the deserve to win mindset. Is that fair?
That's good, David. Well, we appreciate you, man. I'm not going to applaud you because that might be perceived the wrong way, but I do appreciate you being on the show, man. I respect you being out here. Thank you.
And listen, as much as we're going to disagree on a whole bunch of things, but I find your writing and your insights to be rather interesting. And we're not going to agree on everything, but I think we can agree that the lead generation industry it's a very dirty business, and unfortunately, a lot of people get caught in the crossfire, especially the small businesses you were talking about. But it's a thing that happens, and if you don't want to get hit by a truck, don't play in the street. That's my advice.
All right, David, I appreciate you. Thank you very much.
Thank you, Eric.
Well, folks, this is why people don't like professional TCPA litigators. He was not very nice. I'm not sure that I enjoyed that. What did you guys think? Let's start with you, Britt. What did you think, my dear?
Well, first of all, who has landline phones anyways that connects to the wall? I'm pretty sure we're in 2025. And I mean, I know he did say he had a cell phone, but we're just past that. But anyways, what did I think of him? I didn't really like him. I usually like the interviews, but I just feel like he didn't come off as slimy. Maybe you had different thoughts, but maybe he's like a hidden slimy. But putting that aside, I mean, this is, on the positive note, a good reminder for us folks that there are people out there like David who probably sit around all day at his desk waiting for these calls to happen. And I don't know how truthful he was being about not filling out forms, because I feel like maybe he would be the type to actually fill out forms and induce these lawsuits. But it does serve as a good reminder for people to, if you're working with third-party vendors, if you are engaging in lead generation, it is a good reminder to be knowing the folks that you're working with, vetting out your agreements and those things.
That guy is 100% setting up the lawsuits.
Yeah.
He's sitting there with his GoPro, just waiting with sweaty palms for the phone to ring. I mean, come on. What do you think, Tommy?
Yeah, I disagreed with a majority of what he said, but like Brittany just mentioned, right at the very end, he did say something which I think is important to remember, which is know who you're doing business with and make sure you can trust them, because we've seen this a few times throughout this year, even with FTC enforcements as well. You need to vet your third-party vendors, and you need to make sure you have provisions in your contracts that will protect you if someone like David comes after you.
That's it? Those are your points. So what do you think about David? Why are you going to turn everything into a compliance seminar?
She's our compliance lawyer.
I was trying to be constructive, but I don't believe that he got fired because he received too many robocalls.
Right.
Was that not the most absurd thing you've ever heard in your entire life?
What?
Yeah, and I thought about just leaving it alone, but they just had to come back and just ask him directly. Yeah,
No,
yeah.
there's no way.
Yeah, that's... Anyway. Pooja, what did you think?
I cannot wait to depose this guy one day. It's going to be a lot of fun. I'm going to have a ton of fun with that. How bad is that guy with analogies? That's what I kept thinking about because, my goodness, I just wanted him to stop doing his analogies. And he just struck me as a guy who's watched too many lawyer shows growing up and, thinks he's a lawyer and thinks he's extremely intelligent. He's not, right? I like that, Eric, you mentioned Diana May and how she kind of pushes these cases, making good law. This guy obviously can't be taken seriously. If you're facing a lawsuit with David Tom, call me. I'll help you, depose the guy, hopefully. But yeah, that's how I felt about the guy. He can't be taken seriously. He's definitely a liar, in my opinion, just based off of his demeanor, right? And the way he was talking. This man isn't actually hurt by these calls. This guy, has a room set up with wires going down, a GoPro. Who uses a GoPro these days? I don't even know. That's really seriously. He even knows the call recording state statutes, right? So that just tells me he's kind of doing this as a living and he's, in the practice of setting up these lawsuits. But, they're out there. Like Tomina said, like Brittany said, we have to be aware of these guys. Unfortunately, they're out there. But, if you're facing a lawsuit against him, I don't think he's one of the serious players.
Well, I don't want to dump on him too much. I mean, he was brave enough to come on here. He was brave enough to be candid. You could say he was maybe a little foolish and he ran his mouth a little reckless maybe. But so I respect him for coming on, but that's about it. I'm not going to lie to you. I struggled with this interview, and I really try to see the good in people. And I don't think he's really as bad a dude as he was putting on. I think he was playing the role of a completely dismissive jerk that doesn't care what happens to small business, that can't see the line between good, well-meaning American people who are trying to just, provide for their families and then just scumbags, right? None of us have any respect for scumbags. And I would like to think everybody has respect for a legitimate business that's trying to do things the right way. Now, where I think there could be a point to disagree is where the line is in between, right? And I don't disagree that the lead generators, many of them are a problem, which is why we created REACH, right? We created Responsible Enterprises Against Consumer Harassment specifically to take the good from the bad, so that people that are in the market that want to find good leads, you go to a REACH member and you buy good leads, and then you feel safe, and you don't have to deal with guys like David Tom. But not everybody knows about REACH. It's not a very well-funded organization yet. It's too bad. We're going to work on that. And so as a result, you still do have people getting taken advantage of by these lead sellers. And, my heart remains with the small businesses, the good guys, the well-meaning guys, not the dudes that are whatever happens. If David Tom goes after a guy that, they weren't trying to do things the right way, then I guess that's on them. But if you're a good, well-meaning business, it really bothers me. And I know for a lot of American businesses, for a lot of people that are listening to this, I know it really steams you when this guy just kind of glibly says, hey, if they go out of business, they go out of business. They shouldn't have bought a lead. I mean, I don't know, man. We've got to have a connection between the punishment has to fit the crime, right? And if the crime is not even negligence, the crime is just hey, I had to deal with someone and that person broke their deal, and now you're going to put me out of business because somebody else broke their deal. That's not right, right? That you've got to live in a world where you can see the difference between that kind of company and a scumbag operating out of Pakistan that's just harassing people and scamming people. You've got to see the difference, right? One, sure, they should be out of business, they shouldn't be existing, and maybe they should be in jail. But the other business, I mean, there's got to be a place in our heart. Even David Tom has got to agree that putting these guys out of business because they made a mistake of who they dealt with, as opposed to a mistake of the heart and what they were trying to accomplish. I don't know. I have a real tough time with that. So I didn't enjoy that part of the interview. I did enjoy him having the guts to come on. I think we're going to see a lot more David Tom. I think there's going to be a lot more of him. He is exactly the kind of guy that would team up with Andrew Perong. That was exactly what I was expecting to hear. But the guy is a bit of a knucklehead. Look, I would say it to his face. Some of the things he said, that was very intriguing to me. And I think you're going to have a really good time in the deposition. But I hope all of you had a really good time on this, our 38th edition of the Deserve to Win podcast. We'll see you next time. Love you all. Bye, everybody.